Be ready for dictation. 5 seconds to go. Start. The Election Commission is a constitutional entity entrusted under Article 324 of the Constitution with superintendence and control over the conduct of the elections. The petitioner has placed no actionable material on the record of the court to indicate that the Election Commission has acted in breach of its constitutional mandate. Ultimately, the manner in which the source code should be audited and the way the audit should be dealt with bears on sensitive issues pertaining to the integrity of the elections which are conducted under the superintendence of the Election Commission. On such a policy issue, we are not inclined to issue a direction as sought by the petitioner. There is no material before this court at this stage to indicate that the Election Commission is not taking suitable steps to fulfill its mandate. At the outset, we take on record that the counsel for the petitioners in unison have stated that the petitioners do not attribute any motive or malice to the Election Commission of India, or for that matter contend that the electronic voting machines have been tutored or configured to favor or disfavor a candidate or political party. However, due to possibility of manipulating the EVMs, there is suspicion, and therefore this court should step in to instill confidence in the voters and the people. Voters have the right to know that the franchise exercised by them has been correctly recorded and counted. At the very outset, the court would like to observe that neither the satisfaction of the Election Commission nor the system in vogue today, as stated above, is being doubted by the court in so far as fairness and integrity is concerned. It is possible, and we are certain, that the system ensures accurate electoral results, but that is not all. If the number of machines which are subjected to verification of paper trail can be increased to a reasonable number, it would lead to greater satisfaction amongst not only the political parties but the entire electorate of the country. This is what the court should endeavor, and the exercise, therefore, should be to find a viable number of machines that should be subjected to the verification of VVPAT paper trails, keeping in mind the infrastructure and the manpower difficulties pointed out by the Deputy Election Commissioner. In this regard, the proximity to the election schedule announced by the SCI must be kept in mind. We could have dismissed the present writ petitions by merely relying upon the past precedents and decisions of this court, which, in our opinion, are clear and lucid, and as repeated challenges based on suspicion and doubt without any cogent material and data are execrable and undesirable. However, we would like to put on record the procedure and safeguards adopted by the ECI to ensure free and fair elections and the integrity of the electoral process. For this purpose, we shall refer to and take on record the features of EVMs. Lastly, we would give two directions and take on record suggestions for consideration of the ECI. I have heard senior counsel for the three petitioners suspect, without however attributing any malice to the Election Commission of India, the efficacy of exercise of the right of franchise through the EVMs, which according to them are not entirely reliable and open to manipulation, and that completely tallying the voter verifiable paper audit trail slips with the votes cast on the ballot unit is the plausible solution to ensure a taint free election. I have also heard counsel for the petitioning association in the lead matter rely on certain reports to persuade the court hold that casting of votes through EVMs is not foolproof and that voting through electronic means has been discontinued by a European nation in compliance with a judicial verdict. He was also heard to suggest, when called upon by the court regarding the nature of relief, the petitioning association seeks that the electoral process in India should return to the paper ballot system upon discontinuance of voting through the EVMs. While a writ petition may be instituted if there is a genuine and looming threat of a right being trampled upon, what is, however, clear from the aforesaid decisions is that such threat or apprehension has to be well founded and cannot be based merely on assumptions and presumptions as is found in the present set of writ petitions. तो ये आपकी डिक्टेशन कंप्लीट हुई। अच्छा मैटर है, इसे ट्रांसक्राइब करिए और ज़्यादा से ज़्यादा लोगों को शेयर करिए जो अपकमिंग सुप्रीम कोर्ट एग्ज़ाम्स की तैयारी कर रहे हैं। थैंक यू।